Okay, very good. Well, I'll go ahead and get us started here. My name is David Barfield. I'm Chief Engineer with the Kansas Department of Agriculture's Division of Water Resources. And I'm the person responsible for making a decision with respect to the applications of the cities of Hayes and Russell to change a series of water rights from irrigation use on the R9 ranch to municipal use for the cities and their customers. So I'm going to provide some introductory remarks, and then the cities are here and are going to make some presentations, and then I'll come back and provide a little more presentation as well. So the purpose of this is a fairly fairly significant set of change applications that are pending, and a fairly complex set, and there's some uniquenesses to them. So we're sort of doing an extraordinary process here of having an informational meeting today to basically explain the applications and what they propose specifically, and then a body of proposed conditions, terms and conditions that would be part of the approval, so that you all can understand those as you seek to evaluate it. And part of our process of processing applications like these changes is to get input from the nearbys. So this is sort of an enhanced version of informing you all, and then getting feedback that we can use to evaluate as part of the decision-making process. So we're here to sort of inform in the first half of this. Actually, I should be advancing. We're here to sort of provide information in the first half of this meeting with respect to, again, what's being proposed and what the proposed terms and conditions would make that set of applications approvable. And then we're going to take a break, and then we'll actually have a public comment period where I will receive from you your comments with respect to the decision that is forthcoming. So that's basically how the afternoon will be organized, and I'll sort of walk us through more of that as we go through. This is not a formal public hearing, but again, an enhancement of our normal sort of process to get input from the public. So just most of you will know this, and both my presentations and the cities are going to be fairly high level. Certainly seeking to help you understand the package and the major features of it. We'll stand for questions and answers if there's a specific part of that presentation that we didn't make clear, or if you want more detail. Obviously, we've got all this information on our website, and the documents there represent sort of hundreds of pages of information, but we're going to do our best to provide a concise and understandable summary of these things. So because the city's proposal would move more than 2,000 acre-feet, more than 35 miles, it will be subject to sort of two different processes to have the package approved. The first, and the one that's before us today, that's before us now, is whether the change application should be approved under the Kansas Appropriation Act. And then when that step is complete, it'll result in contingently approved change applications. And so the second step that's necessary for this proposal to move forward is a review under what's called the Water Transfer Act. And it looks at a different set of decisions, and it has a panel of three and a formal hearing process. It's actually an 11 to 20-month process, depending on whether there's a sort of range of dates that are allowed under the statute. Again, the city is proposing to change 7,647 acre-feet of water that's been historically used on the ranch for irrigation use to municipal use for their purposes. So I think I've covered the rest of that. This is just sort of a map of the ranch, and you'll see. Maybe I'll hold this for a while. In this particular map, and there's a different map in the package that I'll talk about here in a minute, but basically The red triangles are the existing irrigation wells as they are approved and have been used historically, and then the blue pentagon shaped are the proposed locations for the municipal wells. And so they're consolidating various existing irrigation wells, authorized irrigation wells, into their new their proposal. I guess some of them are blue and some of them are green. This is a similar depiction, just doesn't have an aerial photo on the background, and I think you've got that in the package that you were presented here if you want to refer to that either now or later. So all of this information pretty much is on our website. We've had this website for since the city first filed its applications, and we've been updating it regularly, and so you'll see the documents essentially that I will be referring to anyway on that website. We actually are videotaping the presentations today, both mine and the city's, and those will be posted on the website here very shortly. We're also audio taping the Q&A and the public comment period, just to make sure that we sort of capture the remarks that are being made. The audio will not necessarily be put on the website. So, but anyway, if you want to refer to any, if you want to get more details, the city's modeling report and all these documents are available there. So I think I've covered most of this. This meeting, again, concerns it with the change process. I'm not taking comments, or we're not taking questions about the water transfer process that is ahead. The change application decisions are prerequisite to the water transfer process. And again, this is an informational meeting. They give you more information, and a part of our public comment decision input in the decision process. So again, once the changes are approved, then the water transfer process starts. So this is just a section of statute from statute in the Appropriation Act that just talks about changes in water rights. And in our Kansas statute, the Appropriation Act provides that somebody who owns a water right can apply to have their water right changed. Those changes can be places of use, point of diversions, use made of water, or any combination of those three things. And here we have the city asking to change all three of them. The use made of water, irrigation, municipal, they're reconfiguring the well fields, and the points of diversions will all change, and the place of use will move from the ranch to the cities. In order for a change to be approved, so water right owners have this right to apply for their water rights to be changed. The owner of the water right, certain things have to be found to be true in order for the change to be approved. The change has to be reasonable. We have to know that the change will not lead to impairment of other water rights. The changes have to be in the same local source of supply. And then receive the approval. So really, fundamentally, it's what we're doing here as we evaluate the city's changes is making sure these things are true and establishing the terms and conditions that make the change reasonable, that ensures impairment will not occur, and so forth. So that's really what the process is all about. And again, I've got ahead of myself here. Are the proposed changes reasonable? Will they prevent impairment? Will the terms and conditions prevent impairment? Do they relate to the same local source of supply? So again, the transfer process is ahead. I'm sort of evaluating this package as if a city or industry within 35 miles, in other words, that does not trigger the Transfer Act, is asking for the R9 ranch's water rights to be changed. And again, what terms and conditions are necessary to prevent impairment and protect the public interest? So that's really the question. Again, the water transfer, weighing the receiving basin versus the donor basin, and all those decisions are for a later process. So just kind of, I'll repeat this slide in a little more detail later, but we're here to get to have this meeting. At the end, I'll basically say, if you've heard something and want to provide written comment for both the Groundwater Management District and me to consider in our processes, we'd like to receive those comments in the next 3 weeks. The GMD, is really the next step in the process. They have to review all of this and make a recommendation to me as part of the process as well. And so I think they'd like to have your feedback as well as they make their considerations. I've asked the GMD to provide a recommendation to me during August, and then I'll be evaluating the full package of everybody's comments and then making a decision in the early fall. And again, then the transfer process would kick off. So, okay, that's my part. I'm going to turn it over. I'm going to switch the PowerPoints to the cities and ask Toby Dougherty to come forward and start that.
Good afternoon. Can everybody hear me? My name is Toby Dougherty. I'm the city manager in Hays, Kansas, and I'm here on behalf of the Hays City Commission and the Russell City Council. I'd like to thank the Chief Engineer and the Division of Water Resources for allowing us the opportunity to present today. The City of Hays purchased the R9, including the perfected water rights, in 1995. In 1996, the City of Russell purchased an 18% interest in the R9. Since purchasing the R9, the cities have utilized the water, farmed the property, and evaluated for future yield. Historic annual irrigation diversions of the R9 have been in excess of 8,000 acre-feet. In June of 2015, the cities filed change applications with the Division of Water Resources. Change applications sought to change the beneficial use from irrigation to municipal, to change the place of use from Russell, or from the R9 to Hays and Russell, to change the points of diversion from 58 irrigation wells to 14 municipal wells. The change application also requested a consumptive use authorization of 7,625 acre-feet. Due to the unique nature, the change application process has been a lengthy one. The cities have worked hard with the Division of Water Resources since June of 2015 to draft an order that conforms with all statutes and regulations. The change application process is unique because it is part one of a two-part process. When the change application is deemed complete, the cities will undergo the provisions of the Kansas Water Transfer Act. Because of this unique consideration, because of the unique situation, the cities asked the Division of Water Resources for a few considerations. The cities asked for a delayed effective date of the order. That allows the cities to navigate the transfer process before the order formally becomes effective. The cities asked for deferred identification of the final well locations. This will be discussed a little further in our presentation. The cities asked the Division of Water Resources to approve the total quantity with the order, with actual usage based on population demand. This is also going to be discussed further in our presentation. This aspect is critical to the long-term and economic viability of the R9. Most importantly, the cities are committed to a sustainable operation of the well field. It is not in the city's best interest, and the R9 will not be a long-term economic project if we don't use it sustainably. The cities plan to agree to a sustainable yield limitation in the master order. This is a unique change application requirement and unique in the state of Kansas. The cities feel they're going above and beyond with this commitment to sustainable operation. Earlier today, I was told there was a couple questions about usage of the property as it is transitioned to a well field. Beginning in 2013, farming was phased out at the R9. 2007 was the last year, or 2017 was the last year of crop production. I believe there was 7 circles in operation in 2017. This fall and spring will mark the final phase of infrastructure removal and native grass planting. So far, I believe about 75% of the R9 has been planted to native grass, and we have a fairly good establishment on most of it. The long-term plans for the R9, in addition to a water source, is cattle operation, and it is also walk-in hunting. Early on in the process, we reached out to the Kansas Department of Wildlife, Parks, and Tourism and asked their interest in walk-in hunting in the area. They were very interested because of the lack of walk-in hunting opportunities, and so once the grass is formally established and we get the well field design, we'll be sitting down with Wildlife, Parks, and Tourism to map out the walk-in hunting utilization. At this time, I would like to introduce 2 more members of our team. Dave Traster. Dave is with the firm of Folston Siefken. David represents the cities of Hays and Russell. And then after Dave, Brian Meier is here, Brian is a managing associate with Burns & McDonnell, and Brian also represents the cities of Hayes and Russell. So I will turn it over to Dave Traster.
Thank you, Toby. So, these changes are unique in some ways, and they're ordinary in others. They're ordinary in the sense that the draft master order that we've been discussing and negotiating with DWR complies, as Toby said, with all the rules and regulations. There are no waivers of the regulations, either DWR or GMD regulatory requirements. But we did file these applications in preparation for a transfer, and the normal process for making a change involves testing and design, figuring out where you want the well, then a change application, then approval, and then well construction. Because the transfer proceeding is coming up, the testing, we asked for permission to move the testing and design process to the end, so that the testing and design of the wells can be done in conjunction with the design of the overall project, the pipeline, and other components of the infrastructure. And DWR was willing to do that. As a result, we asked for some flexibility, greater flexibility than is normally the case with respect to the exact well locations. And I think Brian Meier will talk a bit more about that here in a few minutes. These are perfected and certified water rights with priorities in the 1970s. When they were perfected, there were years where there were over 8,000 acre feet of water diverted in a single year. If the chief engineer approves the master order and the change approvals as it's currently drafted, the quantities will be reduced under the regulations to the lower of the quantities set out in the certificates of appropriation, or the quantities that were historically consumed on the ranch by irrigation during the perfection period. Based on DWR's consumptive use and related rules, the city has originally requested 7,625 acre feet per year be converted to municipal use. After lengthy discussions, lots of back and forth with DWR on this and other issues, again, if the master order as drafted is approved, the cities will agree to reduce the total quantity that can be diverted in any 1 year to 6,756 acre feet per year for municipal use. And if the chief engineer approves the master order again as it's currently drafted, the cities are prepared to further limit the diversion to the sustainable quantity that Toby talked about, that is 4,800 acre feet per year on a 10-year rolling average basis. And so during any 1 year, the cities might, in the future, divert up to 6,756 acre feet, but they've got to stay on average on a 10-year basis, 10-year rolling average, to 4,800 acre feet per year. In addition, the current draft of the order limits the quantities that can be ultimately taken from the ranch. I say ultimately, can ever be taken from the ranch, to the city's reasonable needs. So those quantities that I've talked about are maximum quantities, but there's a further limitation based on population. DWR typically looks at a 20-year population growth and projection, and gives the city up to 40 years to perfect a water right. And because this project is designed and anticipated to be much longer, and we don't know how fast either of the cities will grow, we've used a little bit different approach that's still in compliance with the regulations. This is partly because of the need for financing. We're going to need to be able to take this to the banks in order to borrow the money that we need. We're going to have to be able to show that the full quantity can be diverted if it's needed. So the city's asked for, the chief engineers agreed to allow the quantities to increase as populations and other needs increase. So the draft master order starts with the standard approach to determining reasonable needs for cities by using the average quantity of water used by municipalities in the counties that run north and south from Ellis County, and in Russell's case, north and south of Russell County, and what do municipalities in those corridors use on average, and multiply that times the population and the 2% growth over a fairly short period of time. The quantity can increase, but again, it's an increase based on population, and if we can't show the need, then we won't be able to use the water. So the quantities, under any circumstances, won't be able to exceed the 6,756 acre feet, and limited to the 10-year rolling average. Those are the upper limits. Right now, Hayes and Russell combined use around 3,000 acre feet of water, and the ranch is proposed to be developed on a phased basis, so not all 14 of the municipal wells will be drilled at first. So we sincerely do not anticipate diverting anywhere close to the quantities that I've talked about. The rate, the actual pumping for the ranch is likely to be significantly lower than those numbers. The rates of diversion will also be dramatically reduced if the chief engineer signs the current draft of the master order. If they were not reduced, those 14 wells could average about 2,600 gallons a minute, which is unrealistic and not needed. So the draft order, master order, limits the rates from those 14 wells to an average of less than 1,000 gallons a minute. And we anticipate them being significantly, actually diverting less than 500 gallons a minute. So if the master order is approved as drafted, the quantities of water that can be diverted in the long term are sustainable, even though the water rights and other water rights in the region are not limited, or not so limited. With that, I'm going to turn it over to Brian Meier.
As Dave said, I'm Brian Meier with Burns McDonnell. I do appreciate the opportunity to be here today. And as you've heard, it's kind of a reoccurring theme. This is a unique process because of the length of the process, the two-step nature of the process, the change applications followed by the transfer process, which creates some unique challenges. And they've been mentioned in general, and I want to go into a little more depth on a couple of those specific challenges. The first one is looking at taking those 50-plus irrigation wells, consolidating them into 14 municipal well locations. That, and knowing that this is a lengthy process, and as Dave said, deferring the significant field investigation to a later point in the study, we had to look at what's the best reasonable alternative to determining those locations. So we started with what are going to be the requirements of those change in point of diversions. Well, you want a reasonable control over it. So this example shows that we're looking for well E, proposed well number E for our well E for as a municipal supply point was close to these 3 wells. So what would be the basic requirements? Well, we need to be within a half a mile of each of those former irrigation points of diversion. So you have those circles and you create this rather unique geometry or area that you identified. Then another requirement that was identified was we want to stay at least or a minimum of a half a mile away from any other authorized point of diversion. So that you see down here in the shaded color which also added to the geometry or changed the geometry of that area that would meet those requirements. And then, of course, as was stated earlier, we have to be within the same source of supply. So then, based on some field investigation, just field observation, picking a spot that looked like it was compatible with drilling a municipal well, selected that point, and then that facilitates later when the field investigation is, it's time for the field investigation, the actual well location to be determined based on that gathered field data, and as long as it falls within that shaded area, it's going to meet all those requirements that we identified. This is just another example. It shows how those unique geometries were set up. Same set of requirements within a half mile of the existing points of diversion, more than a half mile from any other authorized point of diversion, and in the same source of supply. So once we establish that, we're looking at the next, one of the next themes that you've heard a lot about that makes this project unique, and that is the commitment to sustainability, which is such an important element of any public water supply planning process. This has to be something that's viable for the long term. So how do we determine that? We know we had the 6,700 acre feet determined from the consumptive use. Well, what's the real number that defines sustainability? And in this case, sustainability is those withdrawal rates that will result in long-term stable water levels. So how do we determine that? Well, we went out and looked to see what tools were available. And of course, one of the main tools available was the GMD5 model, which had been reviewed, vetted, and approved for use, for similar use. So that seemed like the logical tool to use. And of course, it covers the entire GMD, which encompasses the range. So it seemed like a good path you could take. But the next step was to make sure that in the range area that the model was going to perform adequately. We needed this. So we picked a period where we had good information regarding what was produced on the ranch, good numbers, good data, and we also had good observed water level responses during that same period. So the model was run through that period with actual data and then compared to the observed water level changes on the ranch. And this graph demonstrates a very close correlation of those water levels that the model produced and the water levels that were actually observed. That gave us confidence that this was a good tool to use to move forward to calculate sustainability. So the next step was then to do iterative model runs, to look at what that capacity or that diversion rate was that would produce those sustainable water levels. In this particular graph, on one side you see the quantities diverted in various scenarios, and on the bottom you see the change in water levels. And so we ran a number of scenarios using those same observation points on the ranch to look for that stable water as a result of the model run. Well, the green box you see in the middle was really a band that represents that stability. You know, and in general, the 4,800 acre feet was the number that was identified as a sustainable yield where you would see those relatively stable numbers long term. So those model runs were used to calculate that. Additionally, throughout the modeling process, there was a lot of interaction with Division of Water Resources to use the model to look at different scenarios, different operating scenarios, and look at the response of water levels in the range. And those were documented in the modeling report. But those included expanding the runs to up to 51 years, including a 2% drought in the run period. So there was extensive effort put into the modeling to see how the ranch would respond and what the sustainable yield would be. So what does that sustainable operation really mean? Well, as Dave said earlier, it's in any given year, we have the capability to produce up to a maximum of the 6,700 acre feet. But on a 10-year rolling average, 4,800 acre feet per year rolling average is the max. Now, and also as was stated earlier, with the planned phased development of the ranch, it would be a process where it would be a long time to work into that upper levels of development or those higher quantities. Additionally, the observation was when we looked at this, the sustainable approach, when we looked at what even what the Great Bend Prairie Rack goal was to provide sustainable groundwater withdrawals by 2025, I believe, we felt like this was a good match and a good approach to take. With that, I'll turn it back over to Dave.
Okay, so from here I'd like to do sort of a brief overview of the draft approval documents. Again, we've got these on our websites. There's one that I think you referred to as the master order. It basically is, again, a draft proposed order that would approve these applications. Again, we're not through the process yet, so it's not final. Again, this input we're receiving from the GMD and you all is going to potentially affect the order. And then we've got another document that's really an attachment to the proposed draft master order, which are the individual approvals, which show the specific terms and conditions of each individual water right and its attributes, proposed attributes after the change. So I'm just going to go through and highlight them. The cities have sort of talked about some of the features, so I won't go in a lot of detail where they've talked about it. Now, first of all, why do we have this draft approval document at this point? I wanted to just sort of talk about our general process for reviewing applications. Normally, we receive an application from a water user that wants to change a water right. We review that application for completeness. We review it for conformity to the rules. There's sometimes some back and forth with the applicants to make sure that that change is going to meet their needs that are spurring the change and again meets our rules. Once we have a package that's complete and meets the rules, then we gather public comment from what we call the nearbys, from the affected community. We receive their comments and evaluate those. Once we have then those packages where there's a groundwater management district, which is the case here, we send the application and any comments we receive to the groundwater management district, and we receive a recommendation from them with respect to approve, deny, or approve with these terms and conditions. After we receive the GMD recommendation, it comes to us, and then we make a decision to approve or not approve, and if approving, under what terms and conditions. So again, with the complexity of this, we thought, in addition to the change applications, we would show you and the groundwater management district the proposed terms and conditions for the package as a whole and for each and every specific water right. And so that's what these documents represent. Again, no decision's been made on the final documents. Again, we're still in our process here. But I will tell you that we've worked hard with the city to come up with a set of proposals here that meets their needs and also fully meets the statutory and regulatory requirements. We believe that. Now we're here and to hear from the GMD and you all to make sure we haven't missed something. So I've showed you the documents. That's just what the first page of the master order looks like and just what one of the individual approval drafts looks like. So again, so I'm going to walk through the major features of most of these. The narrative here is in that handout, which we've tried to sort of look at the major features of the proposed approvals and really the applications. Again, changes in the use made of water, the place of use, the points of diversions, and Brian's already done a good job of explaining sort of the flexibility we're providing in this order to move up to 1,000 feet within those purple areas that meets all the statutory or the regulatory requirements. So after the changes, we apply, when we do these changes, again, each and every water right is evaluated separately, and we do an evaluation of the consumptive use as we change from irrigation to some other use. Rules, we have a set of rules, KR 5-5-9 through 12, that basically determine how much of the irrigation use can be changed to a new use. So we've reviewed those requirements and applied them to each and every water right and then summed them together. Now, the rules generally look at, rather than looking at the historic use, we look at the maximum historic acres, and then we typically use the net irrigation requirement to determine the consumptive use that can be changed. Where alfalfa is demonstrated, then we use alfalfa. And about 55% of the pivots had alfalfa as a crop during the perfection period, and the rest used corn. So there's a table that goes on several pages that basically tabulates the crop that was used for each water right and the resulting consumptive use applied to that water right. So, and then they were summed together to get the 6,700 and change total. So the next thing, and the city spoke about this, is the imposition of a 10-year rolling average limitation that's tied to their evaluation, which we reviewed, as to the long-term sustainable yield of the ranch. And again, that was found to be 4,800 acre-feet. This is not in our rules. This is not a normal provision. Normally, the consumptive use is the number. Really, I'll take responsibility for this. This is an imposition that I made to say, this is a long-term water supply. You're coming asking for a long-term supply for the ability to scale this up over time. I need for me to say this is reasonable, I need you to show me that you can sustain this use. And so that's where that number came from. There is provision in the order that if, right now, this imposition of this special condition is for the city's benefit. It's not to provide more water to the region. So they base it on this area's been closed, and as long as it remains closed so that the city benefits from them restricting themselves, they're good with it. And so if we open up, they use the best science, at least in our view, the best science. They wanted the opportunity of, a decade or two, if sometime in the future there's a better groundwater model and it demonstrates a different number, a better number, they want the opportunity to come back and argue that. Now that would take them bringing the evidence and the chief engineer at the time reviewing that and approving it. And most likely, I can't speak for future chief engineers, but most likely there'd be a hearing process, there'd be some public process to review that. So improved science could change that. I'm not expecting that to happen, but better science may do that. They basically, if we open up this basin to new appropriations, then the restriction goes away because this is for their benefit. And the same with the restrictions in the Ark River, Ikuka. Again, David spoke a little bit about the reasonable municipal need when we approve a change. It has to be reasonable, so I can't approve a change for more than the city needs. So we've restricted them to the reasonable municipal need that we projected for the coming 20 years like it was, and then an opportunity to scale that up as they develop population or more industrial customers. And again, in one of the attachments, attachment E, sort of goes through the details of that procedure. If you want to talk more about that later, we'll do that in the Q&A. So their rates of diversions, again, I have to find that the change is reasonable, the rates are reasonable. Again, as Brian indicated, the irrigation rates are needed to supply irrigation demand during just a narrow part of the year. Those rates are not reasonable for the change. So there's a very complicated procedure that I hope you all don't want to know about in this setting. We can sit down with those who want to talk about, but we have a table E that works through how we did this. And so they've got these wells that each of them have different quantity limitations and rate limitations. They're combining those to a new set of wells, a lesser set of wells, and in some cases, one PD, multiple PDs have under a certain water right, and they're going to different consolidated wells. So again, we can walk you through this if you really want to know it. But again, the city is giving up a lot of rate, as I think Brian mentioned. We have reporting requirements in the draft master order, monitoring plan, and again, as the city mentioned, there's an effective date. These changes will not become effective until two things happen. Number one, assuming they're approved, the changes are approved, then they are not effective until there's an order from the hearing panel, and then really until Hayes enters into a written contract to develop the well field and the remaining infrastructure. So they may get through the change approval process and get through the water transfer process, and then not be able to get financing, or something else could cause a problem. So once the changes are approved, the transfer is approved, they get all their easements and all that, and issue contracts, then the changes are effective. If any point in the process the city just says this isn't going to work for whatever reason, the changes actually do not go through, and the water rights remain as they are today. And we have a date when it will happen, but again, if the city isn't ready, they can ask for extensions. So also in the packet then are the individual approvals, every water right. We have a draft of what that approval document would look like, what quantity it's restricted to, what rate it's restricted to, if there are any restrictions that are combined with other water rights or other points of diversions and that sort of thing. Again, all of this is on our website if you want to go there for more. And again, I think I've pretty much hit this before. We would like, if you've got written comments, we're after this meeting, we're happy to have them. The GMD is working through its process, so if you could provide those by July 13th, which is 3 weeks and a day from today, that would facilitate their review and our review. Just send your written comments to us, because really, and then we'll make sure that we have them, and to make sure the GMD has them as well. So.